Welcome to Rapid Fire Wednesdays, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, a partner in our San Diego office, and I'm joined as always by Miki Matrician, co-managing partner of our Boston office. How are you doing this week, Miki?
I'm good. How are you, Kim?
I'm doing pretty good. It was a relatively quiet weekend, so to speak, kind of, sort of. This week we are going to discuss the lawsuit that was filed to challenge the implementation of the H-1B restrictions and that $100,000 fee. And we're also going to explain the Department of Labor's initiative, which is called Project Firewall. So, Mickey, at the end of last week, a few organizations filed suit challenging the H-1B Presidential Proclamation. They allege the $100,000 fee in the proclamation is an overstep of the White House's authority. So, can you tell us more about this suit, which dropped on Friday of last week?
Yeah, absolutely. So there's now a suit filed in federal court in California, and it is challenging, as you said, the H-1B proclamation, which was issued on September 19th. Plaintiffs are basically a coalition of labor unions, healthcare providers, schools, and religious organizations that came together to file the suit. And essentially, the proclamation conditions the entry of certain H-1B workers on the payment of $100,000. The proclamation cited its legal basis under INA 212F and 215A, and those are provisions in the immigration laws that allow a president to restrict entry of foreign nationals into the US when it is deemed that their entry would be detrimental to the interests of the United States. And the basis of the lawsuit is the argument that although a president does have the authority to restrict the entry of foreign nationals, this proclamation is trying to override the existing laws on the H-1B program and that that's not permitted. The law that Congress had enacted already provides the H-1B system with wage protections and a cap on H-1B numbers and the filing fees that are required, and the proclamation conflicts and supplants the structure that Congress created for H-1B workers. So, in the lawsuit, the plaintiffs also allege that Department of Homeland Security and Department of State violated the Administrative Procedure Act. Normally, that act, the APA, requires agencies to follow the notice and comment process before implementing significant changes in the regulations. And during that process, the government is supposed to collect feedback from stakeholders. The plaintiffs are alleging that the administration skipped the necessary process on rulemaking that's required under the APA. And then finally, the plaintiffs also describe the proclamation as being arbitrary and capricious because it's so broad and disregards the significant negative impact on small businesses, nonprofits, and important sectors like schools, healthcare, and communities, especially the underserved areas.
Yeah, right, Mickey. They are asking the court to declare the proclamation unlawful and block the implementation of that $100,000 fee. So we'll continue to monitor the suit closely and we'll share any updates as they become available. So, next, let's talk about the Department of Labor's Project Firewall, which is a new initiative. That initiative was launched on September 19th, the same day as the H-1B proclamation, but it has gotten a little less attention. And despite the fact that it's gotten a little less attention, it is very important for employers to prepare their compliance files. So, this is an H-1B enforcement initiative that purports to protect the U.S. workforce by targeting employers that are accused of displacing U.S. workers in favor of foreign labor. So, this comes on the heels of emails that employers have been getting from disgruntled U.S. workers who allege that they are not being considered for jobs which are being taken by foreign born workers. These emails list at the bottom the website guestworkervisas.com, which is essentially a job board based on Department of Labor disclosure data from past labor condition applications that have been certified by the Department of Labor. So the website appears to be providing template language for US workers to use in order to send these emails to employers and to copy congressional offices as well.
Yeah, and we're not sure what the relationship is, between these websites and the launch of the Department of Labor's Project Firewall initiative, but it certainly does look to be related and does, contribute to the scrutiny of the H-1B program. And in the past, to initiate an LCA investigation, The Department of Labor needed to have received a complaint by or on behalf of someone who claims to have been harmed by an employer's noncompliance with the LCA regulations. And what this Project Firewall does is it eliminates the requirement of a complaint and allows the Secretary of Labor to initiate investigations of employers if there's a reasonable cause that an H-1B employer may not be compliant. So, if ultimately the employer is found to be in violation, the employer could be required to pay back wages and civil penalties. Employers could also be suspended or debarred from using the H-1B program. So, the Department of Labor's announcement says that it will work in collaboration with the Department of Justice's Civil Rights Division, EEOC, and USCIS. And the Department of Labor can receive referrals from DOJ or EEOC in the event that a US worker thinks that they have been discriminated. So, Kim, what are your thoughts about what type of employer will first be the target of this initiative?
Yeah, so I know as we've been, talking about, we think that it will likely be the IT consulting companies, particularly from India. So that was also the focus of the H-1B proclamation with the $100,000 fee. And in addition, H-1B dependent employers should be prepared under this Project Firewall as well. But regardless, all employers should really be ready for an audit or an investigation. So, as you say, Miki, employers may be liable for back wages if they are found to be in violation. And the civil penalties can be very hefty. So, there could be fines of up to $2,364 for failure to meet working condition attestations, or if there's a defect in posting the required notice, or misrepresentation on an LCA, or even violations related to strikes or displacement of U.S. workers, or violations of the public access requirement. Fines can also go up to $9,624 for willful failure pertaining to wages, strike, posting, or displacement, or a willful misrepresentation on an LCA or discrimination against an employee. So these are not a one time fee per investigation, it's actually per violation. So it can get very costly very quickly. So, Mickey, can you talk to us about how HR and global mobility professionals should prepare for these audits or investigations by Department of Labor?
Yeah, I would say that now is really the time to do an internal audit of all public access files, and HR mobility teams should ensure that there is a public access file for each LCA filed and use a checklist to ensure that the required components are in there. So the certified LCA, actual wage memo, prevailing wage documentation, benefit summary, and evidence of posting the LCA. It's also really important to remember that public access files outside of the retention period should be purged so as not to expose your organization to risk based on errors in public access files that should have been purged before. So the retention period is 1 year after the last date of employment under the LCA or 1 year after the LCA expires, whichever is later.
Yeah, so it's good advice, Mickey, especially with purging those documents that can be purged. And before we wrap up this Rapid Fire Wednesday, we have one last update on Venezuela temporary protected status. So on Friday afternoon, October 3rd, the Supreme Court issued an order that upholds their previous order to terminate Venezuela TPS while litigation continues in the courts. So this means that for some workers, their TPS designation and work authorization is expired immediately, others not until November 7th, and for a small group of individuals, not until October 2nd, 2026. Which date applies is very much based on individual circumstances. So, with that, I guess that wraps up this week's Rapid Fire Wednesday. We'll continue monitoring legislative, regulatory, and court developments, as well as agency guidance, and provide updates in future episodes as we hear of them. As always, for all the latest updates to the immigration landscape, please follow WR Immigration on LinkedIn, as well as Mickey and my personal profiles for breaking updates and insights. We also transcribe each and every Rapid Fire Wednesday episode and share it through our weekly newsletter, which you can subscribe to. The link to subscribe can be found in the video description. So thank you for joining us, and we'll see you next time. Great seeing you as always, Mickey, and hang in there with all these crazy changes going on.
You too, Kim.